Good evening, everyone. I am C. Amarjain, the moderator of this webinar. We are delighted to welcome you all in this webinar being organized by CCLEA and NPO Committee of ICI. It is my pleasure to be the moderator in Know Your Series 50 webinar on economic offences in Bhartiya Nyaya Sanhita 2023 on 8th Feb 2024 from 4 p.m. to 6 p.m. being organized by Committee on Commercial Laws, Economic Advisory and NPO Cooperative of ICI. In a short while, we will start this webinar. But before that, I would like to apprise you about CCLA and NPO committee. So this committee is focused to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social value, while combining analytical foresight and commercial acumen. One of the core areas of this committee is to serve the multifunctional task of analysis, knowledge dissemination, inputs to regulators on policy formulation, to develop and publish technical guidance, background material, etc., and to create awareness for professional opportunities for chartered accountants in commercial laws, economic advisory, and NPO cooperatives. Our eminent speaker will talk on economic offences in Bhartiya Nyaya Sanhita 2023 in this webinar, and we hope that the same shall be useful to all the members here. Before I would like to call our eminent speaker today, CA Pranav Pramod Astigar, I would like to give a brief introduction of him. So CA Pranav Pramod Astigar is a BCom, FCA, LLB, FAFD certified and AML specialist. His area of expertise is the forensic auditor for law enforcement agencies. He is having rich experience of working with law enforcement agencies and participated in the investigation of sensitive economic offenses as forensic auditors. Apart from regular forensic audits, he is also a regular speaker on the audit and taxation of charitable trusts and AML laws at the branches and CPE chapters of the institution WIRC. With this, I would like to call on the virtual stage CA Pranav Astigar. The stage is yours, sir.
Thank you. Thank you. Am I audible to you, Amar sir?
Yes, you are audible, sir.
Okay. So shall I start?
Yes, sir.
Okay. Whether my screen is visible?
Yes, it's visible, sir.
Okay. Thanks. Good afternoon, everyone. At the outset, let me take this opportunity to express my sincere gratitude to the Committee of Economic and Commercial Laws and NPOs of the ICAI for inviting me to speak on this topic called Economic Offences in Bhartiya Nyaya Sanhita. Friends, when we say economic offences, it means we are dealing with the criminal laws. And when we are dealing with criminal laws, it is expected that we should have at least rudimentary knowledge of the criminal law. When working as a chartered accountant, I will throw light on some practical aspects which we often which are often skipped from our audit when we conduct audit for our clients. What are economic offenses? See, offense is an offense against society. Every offense is an offense against a society. It is not against any particular individual. Although there are some specific offenses specified in the IPC, which are generally private in nature, which do not affect the society per se. But every offense has its own social bearing. It is, of course, a stigma to a society. If a person commits murder, it is against a society. It is not a question of a life of an individual which is lost, but it poses several serious societal questions. And when we talk about economic offenses, like other offenses, are not limited to the individual, but as stated by Supreme Court, which is appearing, the slide is appearing on your screen. As Supreme Court has said, economic offenses stand as a different class as they affect the economic fabric of the society. During my professional career, friends, I have observed that there are thousands of people who have affected because of economic offenses. Even in a single FIR, we could trace almost 23,000 affected parties, affected investors. So economic offenses, although they are against the society, but they pose a serious threat to the national security also. For example, take the example of terror funding, or take the example of Naxal funding. Even a simple offense can act as a source of funds for creating a national security problem. I will discuss those aspects in my deliberation. But when we say economic offenses, they have a larger bearing on the society than a murder. Till the date, we were dealing with Indian Penal Code 1860. The question is why government felt it appropriate to enact a specific law in 2024. Let us go to some history. Although IPC was enacted and codified in 1860 and it came into effect from 1st January 1862, its drafting process began way back in 1835. The first law commission of British India was chaired by Lord Thomas Babington Macaulay. He was a British historian and a politician. He was instrumental in drafting our Indian Penal Code, which has ruled this independent India since last 75 years. Question is question is not that there are some drafting mistakes in Indian Penal Code. There are two aspects have to be taken into account. First, the efficacy of the provisions of Indian Penal Code, as well as whether those provisions stood the test of the time. If I say there are n number of provisions, I cannot exactly put the numbers, but there are a substantial number of provisions of the Indian Penal Code which have stood the test of the time. Of course, there are some sections which need some amendment. But if we look at the Bhartiya Nyaya Sanhita and today's sections which we are going to cover in with respect to Bhartiya Nyaya Sanhita, they are exactly replica of Indian Penal Code. However, there are some sections which, of course, have become redundant, considering the change in the societal interest, considering the change in the cultural pattern across India, considering the needs of the society. I can tell you two examples which these two provisions were struck down by the Honorable Supreme Court. First provision was Section 377, which used to be which was used for criminalizing the homosexual acts. In Navtej Singh Johar, Honorable Supreme Court has struck down this provision, 377. Similarly, there was 418, 498, 497, sorry, adultery. Adultery was also struck down by Supreme Court in 2017 in Joseph Shine's case. Apart from that, various structural changes were brought in the Indian Penal Code from time to time. It is not like that amendments were not made in the IPC. Yes, amendments were made in the IPC, but amendments were made in the IPC, but in a piecemeal manner. In very short, provisions were amended. Say you can refer the provisions of Section 376, 375, 376, rape, or you can check about Section 124, which dealt with sedition. The amendments in the Act were brought by not only by the Parliament, but it is the Supreme Court which has interpreted it continuously. And post interpretation, new meanings as required by the time were given to those sections. So what I wanted to say earlier, the law was already amended. It is not like that IPC was never amended. IPC was amended for meeting the challenges posed by the time. Secondly, as Honorable Home Minister said in the Parliament, the provisions of IPC were intended to protect the interest and treasury of the British Indian government. The IPC, if you look at the provisions of IPC, then you can see, you will refer some provisions which are particularly dealt with protection of British Empire. Offences of homicide, offences against women were given less priority compared to this protection of uh, British Treasury and British Empire. What I wanted to say, it is reflecting in second bullet. The IPC was drafted to protect the interest of British India. Hence, crimes like prison, robbery, and attack on government officials were given more significance as opposed to the crimes of homicide and against women. Accordingly, the present government in center had considered to make existing laws relevant to the contemporary situation and provide speedy justice to the common man. The as well as the third object of the Bhartiya Nyaya Sanhita is, it is to give justice to the victim and establishing an example in the society. This is what Honorable Home Minister said in the Parliament. That is why they have given the name Bhartiya Nyaya Sanhita instead of Indian Penal Code. How they are going to give speedy justice to the victim, only the time will tell. But of course, the intention and objectives are good. Just as I've said, various provisions of the IPC were amended from time to time. And there are some reports which have taken into account by government. Ministry of Home Affairs, in the background note, has stated various reports, which include reports from Law Commission of India, Bes Barua Commission, Vishwanathan Committee, Malimat Committee, Madhav Menon Committee, and latest Justice J.S. Verma Committee. J.S. Verma Committee, you may be remembering, it was formed to deal with the situations or to deal with the questions, legal questions, which come to fore after Delhi gang rape. All these committees have made specific recommendations for amending some sections in criminal laws and reforms in criminal justice system. However, if you look at 111th report, 128th report, and 146th report of the Department-related Parliamentary Standing Committee on Home Affairs, wherein it was recommended for a comprehensive review of criminal justice system in the country, and a need was stressed upon for reforming and rationalizing the criminal laws in the country by bringing or by enacting a comprehensive legislation instead of making peaceful amendments in the criminal laws. Although this was the background of Bhartiya Nyaya Sanhita, the current government in 2019 had appointed a committee under the chairmanship of Vice Chancellor of National Law University, New Delhi, to start consultations with the stakeholders in the society for creating as stated in the website on the slide, for creating a robust legal structure in the country. This committee started its work in March 2020, and it invited suggestions from various quarters. Friends, you would be astonished to know it received recommendations from the government of India, from various state governments, also from Supreme Court of India, various high courts, law commissions, experts, academicians, law practitioners, and more than 1,000 IPS officers. There were more than 3,200 suggestions from various stakeholders for enacting the Bhartiya Nyaya Sanhita. After careful examination, the first draft or the report of the committee, the NLU committee, which is known for this report on consultations to the government in February 2022. And that's how the Bhartiya Nyaya Sanhita bill was drafted, and it was placed before Lok Sabha on 11th August 2023. As stated earlier, as I already stated, the Bhartiya Nyaya Sanhita seeks to replace the provisions of Indian Penal Code 1860. IPC had contained 511 sections, whereas Bhartiya Nyaya Sanhita in its original form contained 356 sections. However, this bill, which was placed in Parliament in August 2023, was withdrawn by the government, and a revised bill was introduced in December 2023. The reason for withdrawal is that was the reason for withdrawal was to consider the observations of various stakeholders as well as to rectify the mistakes. What kind of mistakes? For example, theft was treated as a cognizable offense. Theft was treated as a cognizable offense. But if you look at the provisions of the law or the first bill, then snatching, a more grave form of the theft, was placed as non-cognizable offense. So be it. The second draft was placed before the Parliament in December, and that was passed in Lok Sabha and Rajya Sabha. It has been signed by the Honorable President of India. Mere change of 2 sections was observed, and now this Bhartiya Nyaya Sanhita has 358 sections on its statute book. Friends, when we say economic offenses, what kind of economic offenses we are talking about? We will take only those economic offenses which are severe in nature, as well as a chartered accountant, which we are going to deal with during our regular professional practice. See section 178, counterfeiting coin, government stamps, currency notes, or bank notes. Section 178. This section 178 is the result of merger of 2 previous sections, 262 and 498A. 489A, sorry. 262 was actually dealing with counterfeiting government coins and government stamps, and 489A was dealing with currency notes. So the 178 in Bhartiya Nyaya Sanhita is the result of merger of these 2 sections. What this section says? I am reading the bare provision for you. 178 says, whoever counterfeits or knowingly performs any part of the process of counterfeiting any coin, stamp issued by the government for the purpose of revenue, currency note, or bank note shall be punished with a imprisonment for life or with the imprisonment of either description which may extend to 10 years and shall also be liable to fine. So the definition is, so the charging section is very simple. What it says, anyone who counterfeits the government stamps. This is what the section is saying. Now, what is the meaning of counterfeiting? Counterfeiting means, in common parlance, counterfeiting can be equated with adulteration or making any fake record. Secondly, see the section 179. Using as genuine, forged or counterfeit coin, government stamp, currency notes, or bank notes. First part, section 178 was dealing with counterfeiting the currency note itself. Section 179 is dealing with using the counterfeit currency note as a genuine currency note. And thirdly, possession of counterfeit coin, government stamp, currency notes. These three sections have some relevance insofar as our audit is concerned. In all the three cases, the punishment is for life or imprisonment, which may extend to 10 years with a fine. But section 179 and 180 specifically deal with, or they equate, we can say they are similar to section 489B and 489C of the Indian Penal Code. These two provisions, if you look at the PMLA, Prevention of Money Laundering Act, section 489B and section 489C, A and B, sorry, they are scheduled offenses. So when we say we are having possession of a counterfeit currency note, it is not like that any person who is having possession of any counterfeit currency note will be put into jail. When we are talking about criminal laws, the mens rea has to be there. Unless the mens rea is established, one cannot be brought to the police station and he cannot be questioned. Friends, how that these provisions are going to affect our regular audit? Take the example of your bank audit. So I can give a practical example. Around a decade ago, we were auditing the accounts of a cooperative bank. In that cooperative bank, after having a heavy lunch, I was just scrutinizing the ledgers and I found that the bank had written off almost 1.25 lakhs in the under the head miscellaneous expenditure. When I called for vouchers, I discovered that the bank has actually written off the value of counterfeit currency notes, which were detected by some other bank in the remittance. In return, on the same day, I personally went for cash verification and also I could trace out almost 80,000 counterfeit currency notes which were possession in the bank. Subsequent to our audit, the police investigation revealed that there was a complicity of the cashier of the branch and some individuals in the society. One individual used to come to the bank on the specific day. He used to exchange the notes with the cashier. He used to take away the coins and he used to deliver the currency notes. sorry, he used to deliver the currency notes to the banker. Unfortunately, there was no forged notes vigilance center at the branch or even at the regional office or head office level of the cooperative bank. Having said so, on the FIR was immediately registered when we were conducting the audit, and the matter was put into legal sphere. This problem is very serious. Counterfeiting currency notes. If you look at the latest master directions of the RBI, the problem of counterfeit currency notes was given the status of a terror act. Any offense under with respect to counterfeit currency notes has been treated as offense under Unlawful Activities Prevention Act. So these three sections which we were dealing were actually dealing with the provisions of UAPA. Now there is not only a question of counterfeiting or using as genuine or possessing those counterfeit currency notes. Suppose a person is making or possessing instruments or materials for forging or counterfeiting the government stamps, the government coins, or the counterfeit currency notes, then that is also specified offense under the Bhartiya Nyaya Sanhita. It is in section 181. And lastly, making or using documents resembling currency notes or bank notes. But this offense is very this offense, although it is very grievous, but I personally feel that Bhartiya Nyaya Sanhita has not done justice with this act. Making or using any document resembling currency notes is also offense. It virtually amounts to counterfeiting any currency note. But the punishment is only 300 rupees for 182. Using government stamps known to have been used before. Section 184. This is also a replica of previous sections in the IPC. What the section is saying, suppose a government stamp is used, suppose a revenue stamp or a court fee stamp is used in one proceeding, it cannot be used in some other proceedings. You will ask me how this is happening. Yes, this is happening. In Maharashtra police have actually busted a racket where some officials were not cancelling the court fee stamps, and they used to tear up the old stamp and they used to sell to some needy people in the office premises itself, and those needy people once again used to put the used stamp on the records. In one case, I have seen, as a chartered accountant, when we provide a power of attorney in Maharashtra, we provide a power of attorney on 100 rupee stamp paper. Say there were some cases in Maharashtra where it was seen that on A4 page, people used to come with a power of attorney or letter of authority, and they used to affix 100 rupee court fee stamps, and those court fee stamps were used to be taken by the government officials, and they used to sell it without license. So to prohibit that practice, this provision was enacted in the IPC, and that has now been kept in Bhartiya Nyaya Sanhita also. These are economic offences with respect to the government. Let us come to a specific offence: theft. This is again a replica of section 380 of the Indian Penal Code. Whoever intending to take dishonestly any immovable property out of the possession of person without that person's consent moves that property in order to such taking is said to commit theft. there are only two ingredients. First, the property should be movable property, and secondly, the consent of the party is absent. The person from whose possession the movable property is going to take out, his consent is absent. So you may ask me, sir, what about immovable properties? Can I can there be a theft of a well, or can there be a theft of a building? No. There can be wrongful possession of that building. There can be wrongful utilization of or misappropriation of water from the well, but that cannot be moved out from a particular place. But if what if when some specific when some objects are attached to the immovable property, then the test of severability will come into picture. For example, suppose X person is a farmer and he has sandalwood in his farm. So trees can be cut down and can be taken away. So when a property can be severed from the immovable property, it becomes a movable property. One can cut the trees, one can take away the sandalwood with him, and he can sell it. Why I am specifically talking about theft, you will come to know after some point of time. Now there is another section, dishonest misappropriation of property. Friends, what is dishonest misappropriation of property? I am reading the bare provision of the section. Whoever dishonestly misappropriates or converts to his own use any movable property shall be punished with imprisonment for either term, which shall not be less than 6 months, but which may extend to 2 years and with a fine. The provision is very simple. It only says misappropriation as well as conversion for one's personal use. But still, the property should be movable property. It does not deal with the immovable property. How that section is coming to this profession of chartered accountancy? Jocularly, my articles say, sir, when we go to the audit, we ask for calculators and we take the possession of calculators and we use it. This is a jocular form. When I was teaching my articles, they have given me this very rude example. But yes, their logic is clear. Suppose I go to the government office for audit and I ask for calculator, and instead of returning the calculator, I am using it for my personal use. I have taken its possession, I have brought it in my office, and I'm using that calculator with me. This is misappropriation of property. Fine. Now see the context in which we are talking about. Chartered accountants are allowed to act as executor of bill. Chartered accountants are allowed to act as a liquidator. It may happen that by virtue of executor of bill, a chartered accountant may come across, or he may be given possession of some gold material. And if a chartered accountant is putting the low carat gold in that box, which was in possession, and he is taking away the high carat gold with him, this is once again a misappropriation of property. When we do audit, we can also refer to a situation where donations for specific purpose are made to the trust. For example, a trust was given donation by Mr. X for the purpose of construction of building. But instead of using that amount for the construction of building, the trust uses it for purchasing Mercedes for the secretary of the trust, or instead of using it for construction of building, the money is used for building personal residence of the president of the trust. This can be example of misappropriation of property. As against, you can also refer to a situation where the buildings or the quarters of the trusts, say for example, there is a religious trust and it is having some dharamshala with it. And that dharamshala, instead of being given on rent to the pilgrims, it is given to the relatives of the trustee. This is also misappropriation of property of the trust. And if you look at the provisions of section 11, that form 10B, it is also specifically asking you even section 12AB subclause, the explanation to section 12AB, which deals with specified violations, it is also asking you whether the trust has expended the money beyond its objects. For example, we are having an educational institution, but I have used that money for donating a capital expenditure of a religious trust. So instead of spending my money on my educational objects, I am spending the money on my religious objects, which do not form the part of my trust deed. So every penny received by the trust from the donors and its misappropriation will come within the purview of section 314 of the Bhartiya Nyaya Sanhita. Similarly, section 315, it deals with dishonest misappropriation of property possessed by deceased person at the time of his death. X person is lying on the deathbed. He is in possession of say 1 kg of gold, and he says, I've called my daughter. She is residing at some other town. I may not be alive to give this 1 kg of gold to my daughter. Kindly keep Mr. X with you. And when my daughter comes, you can hand over this 1 kg of gold to my daughter as my blessings. The person dies, and Mr. X delivers only half kg of gold to the daughter of deceased, and takes away the half kg of remaining gold with him. This is again dishonest misappropriation of property possessed by deceased person. So if you compare this with a theft, in theft, there is no consent of the possessor. In the case of dishonest misappropriation, there is a consent for transfer of property or for transfer of possession. Property is movable, but there is a consent of the victim that he transfers some property to the accused. Now move to another offense, criminal breach of trust. When we are talking about criminal breach of trust, friends, we have to take into account these provisions of the law. These are essentials of criminal breach of trust. I'm reading the definition. I'm reading the bare provisions of the law. But what is appearing on your screen is the gist of what I'm going to read. Section 316 says, whoever, being in any manner entrusted with the property or with the dominion over property, dishonestly misappropriates or converts to his use that property or dishonestly uses or disposes of that property in violation of the directions of law prescribed in the mode in which such trust is to be discharged or of any legal contract, express or implied, which he has made touching the discharge of such trust or willfully suffers any other person so to do, commits criminal breach of trust. Whatever I have said is specifically available on your screen. First, there has to be entrustment of property or dominion rights over the property to the accused. So victim is giving possession or dominion over the property to the accused. The accused, the person so entrusted, dishonestly misappropriates or converts the property to his own use, the first limb. And in the second limb, there are two subclauses also. Dishonestly uses or disposes of that property or willfully suffering any other person so to do in violation of any direction of law, the direction of law which prescribes the mode in which such trust is to be discharged, and secondly, of any legal contract made touching the discharge. Take a simple example. Whenever we do audit, we often forget to comment on non-payment of, say, provident fund. Although there is section 43B of the Income Tax Act which comes into picture, we are more worried about the Income Tax Act, but we are less worried about the provisions of criminal law. Friends, if you look at the provisions of section 405 of the Indian Penal Code, or even the provisions of 316 of the Bhartiya Nyaya Sanhita, there are specific explanations with respect to payment of provident fund and payment of ESIC contribution. Suppose an employer receives 1 lakh rupees towards the amount of provident fund which is deducted from the salary of his employees, and instead of making payment of that provident fund to the credit of the government, the employer is utilizing that amount for paying his creditors. That 1 lakh rupees which is deducted from the salary of his employees, if the ex-employer uses it to pay the payment of creditors, this is criminal breach of trust, because he is interested with the property under a law, he is interested with the contribution of EPF under the law for making payment to the government, but that person is utilizing that amount for making payment to the creditors. This is criminal breach of trust. This 316 of the IPC is nothing but the replica of 405 of the IPC. 316 of the BNS is the replica of 405 of the IPC. But what about 409 of the IPC, which deals with the criminal breach of trust by public servant? Can a chartered accountant be a public servant? For example, a chartered accountant auditing the accounts of a trust which is substantially funded by the government, can that CA be called as the public servant? If you look at the provisions of Prevention of Corruption Act, then the answer is yes. A person, a chartered accountant auditing the accounts of a trust, is a public servant. Can that ratio be applied in the case of regular criminal law, say IPC or now Bhartiya Nyaya Sanhita? Although I beg to disagree with the court, but yes, in one case where I was a forensic auditor, the court held that a chartered accountant auditing the accounts of a trust, public trust, which is substantially financed by the government, he is a public servant by virtue of Section 21 of the Indian Penal Code. The eighth clause of the earlier Section 21 says, when a person is preparing a report on the matters where the pecuniary interest of the government is involved, he is a public servant. So when we say pecuniary interest of the government, it could be anything. It could be by giving grant to the trust, or government's involvement with respect to collection of taxes. So may I say, when I'm auditing the accounts of, I'm signing the tax audit report, I'm a public servant. Fortunately, this judgment which I was talking about was dealing with only was delivered by trial court. Although the appeal went to the High Court, but before the court could deliver its judgment, police officers have filed a charge sheet. So the accused had to withdraw his bail application, and once again he had to went back to trial court for regular bail. But that was a point to ponder. Are we a public servant? Although not in this, I beg to disagree with the court, because we are not employees of any trust. We are not employees of our auditing entities. We are holding the office of auditor there is a specific office, but there is no employer-employee relationship. We are also not agents of our clients. So on that part, that Section 21 may not be applicable upon us. But yes, in the case of Prevention of Corruption Act, we are public servants. So this 409 of the IPC is not there in the Bhartiya Nyaya Sanhita. So 409 is limited to Section 316. So interesting any person means any person. Now cheating, 400 BC, 420 of the IPC. This provision which is appearing on your screen is nothing but exact replica of Section 420. I am reading the bare provision. Whoever, by deceiving any person, fraudulently or dishonestly induces such person so deceived to deliver any property to any person, or to consent that any person shall retain any property, or intentionally induces the person so deceives to do or omit to do anything which he would not do, or omit if he were not so deceived, and which act or omission causes or is likely to cause damage or harm to that person in body, mind, reputation, or property, is said to cheat. There is another explanation. A dishonest concealment of facts is a deception within the meaning of this section. So deception is defined. A dishonest concealment of a fact. So when we are talking about cheating, the first element is there has to be a deception. There has to be an element to deceive some person. And as stated in the explanation itself, deception means dishonest concealment of facts. So when fact is concealed from the victim, and he is induced by the accused to deliver a property or to consent that person who shall retain any property. By concealing some facts, X person, rather accused, is fraudulently inducing the victim to deliver the property to the accused. And the second limb intentionally induces that person to do or omit to do anything. Rather, I mean, the victim intentional inducement of the victim to commit or to omit the things which he would not do if he is not so deceived. And where such act, whether such commission or omission causes or likely to cause any harm to the person in body, mind, reputation, or property, then this is cheating. What is the example? What is the famous example today we are witnessing? Take the example of Sukesh Chandrasekhar. At some point of time, he is a IAS officer. At some point of time, he is very closely connected with the sitting ministers. He comes to the victim under a false identity. He takes away their properties. He takes away the valuables. He takes away the precious metals or diamonds. If the victim or had the victim was aware about the regular credentials of the accused, say for example Sukesh Chandrasekhar, would that person deliver the precious stones to the Sukesh Chandrasekhar? No. X person, the victim, has delivered the diamonds to Sukesh Chandrasekhar because he has concealed his identity. He has concealed the fact that he is Sukesh Chandrasekhar, and by pretending to be an IAS officer. Suppose I, as a chartered accountant, go to X person and say, I am a police officer and I want to check your gold. And by making false allegation, I say that this gold is smuggled gold, and I'm taking the possession of this gold immediately. I'm seizing this gold, and I take the possession and I leave the place after giving all the acknowledgements and whatsoever. But since I'm not IPS officer, can I take the possession? This is cheating. So there is a difference between criminal breach of trust as well as cheating. In criminal breach of trust, there may not be an element of deception. But in the case of cheating, there has to be the element of deception. There has to be a the dishonest concealment of the facts. Section 320, dishonest or fraudulent removal or concealment of property to prevent distribution among creditors. I am reading the bare provision. Whoever dishonestly or fraudulently removes, conceals, or delivers to any person or transfers or causes to be transferred to any person without adequate consideration any property, intending thereby to prevent or knowing it to be likely that he will thereby prevent the distribution of that property according to law among his creditors or the creditors of any other person, shall be punished with the imprisonment of either term which shall not be less than 6 months, but which may extend to 2 years, or with fine or with both. This offense is non-cognizable. But This offense is non-cognizable, but it deals with our day-to-day life as a CA. Suppose X person is a liquidator and this X person transfers a plot of land, say about 10 acres, to Mr. Y. X is a liquidator and Y is the buyer of that property. And Mr. Y, for a consideration which is less than the stamp value, you will say 50C will come into picture. Of course, 50C will come into picture. When I say below stamp value, it means it is for inadequate consideration. And my intention is to delay or to short pay to the creditors, to delay the payment to the creditors, or to pay inadequate the creditors inadequately. I have transferred a plot of land of 10 acres. This is example of the section 320. Now, what is forgery? Forgery is once again a replica of 467 of the IPC. Whoever makes any false documents or false electronic record or part of document or electronic record with the intent to cause damage or injury to the public or to any person, or to support any claim or title, or to cause any person to part with the property, or to enter into express or implied contract, or with the intent to commit fraud, or that fraud may be committed, commits forgery. So whatsoever is written there, there are only two elements. First, whoever makes the false document or false record. So making a false document is the first limb of forgery. And second element is with the intent to cause damage or injury. So making a false document must have a direct nexus with the intention to cause injury. For example, I am preparing forged sale deed and I'm going with the revenue authorities. I'm going to the revenue authorities for getting my name registered against that forged sale deed. I'm causing injury to the original owner of the land. Similarly, I am preparing a forged will. I am preparing a will. And I am taking away the possession which is intended for the lineal descendants of the victim. And I'm taking away not only the possession, but I'm registering that property in my name. So when I'm preparing a document, it is forgery. Friends, there are some other sections also with respect to forgery in the Bhartiya Nyaya Sanhita, but there are all very small provisions. But the main provision is this forgery. But what I wanted to discuss is falsification of accounts, which is often not discussed in our profession. What is falsification of accounts? In common parlance, we can say there is destruction or alteration of accounting entries. This falsification of records, falsification of accounts is defined in 344 of the Bhartiya Nyaya Sanhita. Earlier, it was dealt with under section 477A of the Indian Penal Code. What it says, whoever being a clerk, officer or servant, or employed or acting in the capacity of clerk, officer or servant, comma, willfully. So mens rea is there. There must be willful act, and with the intent to defraud, destroys. So with the intention to defraud, willfully with the intention to defraud, destroys, alters, mutilates, or falsifies any book, electronic record, paper, writing, valuable security, or account. Any book, any electronic record, any paper, any writing, any valuable security, or any account which belongs to or is in possession of his employer or has been received by him for or on behalf of his employer, or willfully and with the intent to defraud, makes or abets the making of any false entry, or omits or alters or abets the omission or alteration of any material particular from or in such any such book, electronic paper, record, writing, valuable security, or account, shall be punished with the imprisonment for a term which may extend to 7 years, or with the fine, or with both. This is exact replica of section 477. This falsification has its own characteristics. What falsification is suggesting? First, there has to be a mens rea. The words willfully, or with the intent to defraud, they suggest the culpable state of mind of the accused. Secondly, the clerk, officer, or servant, and the word employer used in this section 344 clearly suggest there has to be an employer and employee relationship. There should not be any principal agent relationship. There has to be an employer-employee relationship. So when a clerk, officer, or servant is falsifying any electronic record or any book, or say for example any books of accounts which belongs to or is in possession of his employer, or has been received by him for or on behalf of his employer, and after receiving the books of accounts, suppose the clerk or the accountant makes any false entry. Suppose payment was made to X, but he says payment was made to Y. A very small example. He makes a false entry. Or he omits to pass any entry. Suppose he does not record some transactions in the books of accounts. Is it falsification? The answer is yes. So the first thing, mens rea has to be there. Second, there should be employer-employee relationship, and with and there should be element of destruction, alteration, mutilation, as well as falsification of any record, which includes making a false entry or abetting the omission or alteration of any material particular. There are some 2-3 peculiarities which I have experienced in my practical life. What is the meaning of making a false entry? What can be the scenario in our regular audit where the entry can be a false entry? Once again, we can go to another cooperative bank. We all know some 15 years ago, there was no computerization in the cooperative banks as well. Since that was a cooperative bank, the internal control of the bank was also weak. I have experienced this particular case as a forensic auditor. Probably that was the first assignment of my life as a forensic auditor. There was a clerk of a bank, rather he was a cashier, and apart from his functions as a cashier, he was asked to pass the checks also. He was also asked to pass the checks also in the bank. What he did, he opened a fake account in his name in the same branch. So say X person is a cashier, he opens his own account in the bank, in the branch, And in the bank, you can observe there are some common denominations in which the checks are issued. Say 1 lakh, say 10,000, say 50,000. There were some parties in the bank who were issuing checks with frequent denominations or with the same denominations very frequently. So when a check of rupees 1 lakh comes to his branch, he used to park that 1 lakh rupees to his own account. I'm, I'm telling you the practical scenario what has happened. When a check comes to the branch for clearing, and the value of the check is rupees 1 lakh, he used to park that 1 lakh to his own personal account instead of giving credit to the customer. On the next day, when another rupees 1 lakh come to his branch, then he used to park those 1 lakh in the second day, received in the second day, to the account of the customer against whose check on the previous day he has adjusted that amount in his personal account. So he prepared that channel, but he made a mistake. One fine day, he adjusted rupees 12,560. He was overconfident, but he made an adjustment of rupees 12,560, which is not a frequent denomination of the check. And when he could not tally his clearing control account, that fraud came to picture. So he was making a false entry in the books of the bank. Although there was a weak internal control system, auditor was doing his job, everything was there. But he was making a false entry in his books. He was actually creating his own personal account. He was committing offense falsification of accounts under 344. Similarly, omission of any material particular or omission to pass any accounting entry can also be a falsification of account. For example, a chartered accountant, the employer knew that he has purchased a property, but he does not record that property in the books. That is omission. And subsequently, it is discovered that that property was used by the employer for his own purpose, and subsequently sold off that property. This can be example of omission. But my question is, I'm asking a very serious question. My question is whether mens rea is actually essential. You will say yes, mens rea is always essential for prosecution under the criminal law. But whether this section 344 is independent section or whether it is dependent on other sections, that is the fact of the matter which we should understand. Why I'm asking this question? I've experienced a scenario as a forensic auditor in one case. It was a case of a trust where apparently there was a fraud. If you look at the balance sheets of that trust, there was actually a fraud. The opening balance of the bank was say 1 crore in the previous year. The closing balance say was 1 crore on the 31st March. However, the opening balance was only 1,000 rupees on the 1st April. I am giving just a crude example, very raw example. The closing balance on 31st March was rupees 1 lakh, and the opening balance on 1st April was rupees 1,000. You will say how that happened. Such kind of mistakes were apparent on the record. Even in that case, that what has happened in the receipt payment account, what accounting entry we will pass for the purchase of FDRs? FDR account debit to bank account. So on receipt payment side, we will show it as on payment side. What our auditor did, instead of adding the FDR to his opening balance, he reduced it from the opening balance. So instead of addition, he has given the reverse treatment. And whatever difference was observed, he adjusted that difference in the corpus funds. So this was a case. This was apparently a mistake on record. We have purchased FDR. Instead of adding the same in the investment, it was reduced by the management as well as by the auditor. When they could not trace out the differences, they adjusted the differential amount to the corpus account. My question is whether balance sheet is a part of books of accounts, number one. Secondly, whether this is a case of falsification of accounts, wrong treatment of the accounting entry, and subsequent adjustment of corpus in the balance sheet, whether this is falsification of accounts. There was a difference of opinion. I remember the superintendent of police and entire police department was saying that the balance sheet is a part of books of accounts and they are forged. And I said, although there are some mistakes, but that has never resulted in outflow of funds to the accused. So when accused has not received any fund, how can we charge that person with falsification? Still, the matter was discussed, and I remember the public prosecutor in the case, the legal experts of the police department, they gave their opinion on this particular fact. And their opinion was very crystal clear to understand this falsification. What they said? They said falsification of accounts is a dependent section. This is not an independent section. So unless there is a criminal breach of trust, unless there is a element of cheating, unless there is a misappropriation, there is no falsification. If books of accounts are, if the entries in the books of accounts are correctly passed, but summarizing is wrongfully done in the balance sheet. First, balance sheet is not any book, although it is writing or any paper. But balance sheet is not books of accounts. A wrong entry in the balance sheet without any mens rea or without any monetary benefit to the accused is not a falsification. So 400 and 344, 477A of the IPC was actually a dependent section. So unless there is element of cheating, unless there is element of misappropriation, there cannot be any falsification of the accounts. Although this falsification is not a scheduled offense in PMLA, but as a chartered accountant, we are required to verify the accounting entries. We should know what is a falsification of account. A false entry in the books say, for example, inflation of purchases in the books or sale suppression. This is falsification, and that is a prosecutable offense. And as a expert for law enforcement agencies, I must share my personal experience with you. Law enforcement agencies are not expecting that what we are writing in our audit report, what we are writing in Form 3CB, 3CD. They are more worried about what we are reporting when a fraud is detected, whether the audit trail is established, who is the beneficiary of the fraud, In Maharashtra, we are having separate law, Maharashtra Public Trust Act, or in the case of cooperative audits also, you may experience the same thing. If a fraud is detected, or even in 144 of the Companies Act, if a fraud is detected, what they are expecting? They are expecting the auditors to report the entire mechanism of the fraud, the money trail, the audit trail, the actual beneficiary, the modus operandi, and all those sort of things. So this falsification is very uh, significant part in our audit. Now, my last question is whether a chartered accountant, whether can a chartered accountant be prosecuted under 344 or erstwhile section 477 of the APC? Are we clerk, officer, or servant? The answer is no. A chartered accountant cannot be prosecuted under 4344 because a person who is auditing the accounts of the trust is not the clerk, officer, or servant of his employer or of his client. We, as a chartered accountant, are rendering professional service. We are not the employees of our client. So this 344 is not applicable to the chartered accountants. So friends, these are the some economic offenses in the Bhartiya Nyaya Sanhita, which I discussed. If anyone has any question, he can ask me. Yes.
Hello.
Yes.
Sir, I'm just checking the questions. I'm just segregating out of it. So if we have one question from
Yes.
Sudhakar S. Shinde. Uh, his question is, if a branch manager of commercial bank issues a forged bank statement duly sealed and signed by him to a customer and misuses fund, whether it is covered under economic offense, and what is remedy for customer to recover as he believed statement signed by manager?
Yes. This is the offense under the law. If that person is using that property, that amount in the, if the branch manager is actually utilizing the amount, this is falsification of accounts for 344 of the Bhartiya Nyaya Sanhita. Apart from that, insofar as customer is concerned, I can uh, surely ask the customer to go to the consumer fora. The remedy is much easier than remedy in criminal law. Although criminal law is there, but for his own benefit, if a customer is individual, you should go to the consumer fora.
Okay. Sir, one more question is there. Can an independent internal auditor be considered as an employee and criminal proceedings be initiated in case of misappropriation or theft?
No, internal auditor is nothing. He is not an employee of the management. He is independent professional and he is rendering his independent professional service. So there is no employer-employee relationship between internal auditor and the CA and the employer. However, there are some cases where internal auditors are on the payroll of the employees. They are given provident fund, they are given gratuity. In that case, the internal auditors can be prosecuted.
Okay, sir. And so that's it. All the questions are already carried. Now we don't have any further questions.
Okay.
So we'll just wind up here, and I'd like to thank you for giving such a time for detailing all the things. And I'm I'm hoping that all the members of the institute who have joined today are benefited from this session. Thank you so much, Pranav sir, for joining us.
Thank you. Thank you.
It is over now. Thank you.